Part 1. The Wrong Apartment. There's a specific kind of silence that falls over a city at night. Not peaceful silence, not the silence of a place at rest. The silence of a place that has simply stopped, that has run out of energy and given up until morning. Streetlights humming, a distant car, the occasional bark of a dog that nobody bothers to quiet. She drove home through that silence on a Tuesday night in February. She'd had a long day. Not a bad day, just long, the kind where the hours stretch and the paperwork multiplies, and by the time you look up from your desk, the sky has already gone dark without asking your permission. She was a paralegal at a tenant rights law firm. She had spent 10 years doing work that most people never see, reading leases, analyzing housing codes, building case files, preparing documents that would decide whether families stayed in their homes or lost them. She was good at it. Quietly, methodically, without fanfare, she was very good at it. She wasn't thinking about any of that as she pulled into the parking lot. She was thinking about dinner, maybe a shower, maybe an episode of something on TV before she fell asleep on the couch. She was thinking about ordinary things. She turned off the engine, grabbed her bag, walked toward the building entrance the way she had hundreds of times before, muscle memory, automatic, her mind already somewhere else. And then she stopped. Because outside her door, piled in the hallway under the flickering fluorescent light, were her belongings. All of them. Her clothes still on their hangers, crumpled into a pile. Her books stacked haphazardly, some of them open, pages bent. Her laptop in its bag, sitting at an angle that made her stomach drop. Her kitchenware, her bedding, her boxes of personal things, everything she owned, everything that made that apartment a home rather than just a room, heaped in a corridor like it was nothing. Like she was nothing. She stood there for a moment, just stood there, taking it in. And then she saw the frame. A picture frame, face down on the linoleum. She walked to it slowly, as if she already knew. She picked it up. The glass was shattered. The photo inside, a portrait of her late grandmother, the woman who had raised her, the woman whose eyes she had inherited, was torn at the corner where the broken glass had caught it. She held it for a long time. And then she set it down carefully among her things, took out her phone, and began to document. She photographed the hallway. She photographed every item, every angle. She photographed the door with its brand new lock that her key no longer fit. She photographed the shattered frame and her grandmother's face behind the broken glass. She did all of this before she called anyone, before she called the police, before she called a friend, before she let herself feel anything at all. Because she knew something that Gerald, her landlord, the man who had done this, did not know about her. She knew exactly what he had just done. She knew exactly what it was called. She knew exactly what it meant. And she knew, standing in that hallway at 10 o'clock on a Tuesday night in February, holding a broken picture of her grandmother, that Gerald had just made the worst mistake of his life. Let me take you back, because this story doesn't start in a hallway. It starts the way so many disasters start, with a handshake and a smile and a man who seemed, at first, perfectly reasonable. Part 2. Gerald. Every city has a Gerald. You may not know his name, you may have never met him, but he exists in every city, in every neighborhood where rents are high enough to be worth extracting, and tenants are desperate enough to accept what they're given. Gerald owned 4 apartment buildings in a mid-sized American city, 60 units total. He'd built his little empire over about 15 years, buying properties when they were cheap, leveraging the equity from each one to buy the next. By the time our story begins, he was what you might generously call a successful small-scale landlord. He was not a good landlord, but he had learned over 15 years how to appear like one. He met tenants at move-in personally, gave a firm handshake, used their name at least twice in the first conversation, a sales technique he'd read about in a book. He called himself old school, meant it as a compliment to himself. Old school meant he dealt with people face to face. Old school meant he valued relationships. Old school, in Gerald's mind, meant he was one of the good guys. What old school actually meant in practice was that he kept no written records of anything, assumed his tenants were too poor or too afraid to fight him, and operated his buildings with the maintenance budget of a man who believed that problems, if ignored long enough, would eventually stop being problems. In most cases, he was right. Most tenants complained for a while, then gave up, then moved out. Gerald kept their deposits, rented to the next person, and the cycle continued. He'd been doing this for 15 years. Nobody had seriously challenged him, not once. He looked at her and saw another tenant. He had no idea what she was. She moved into the apartment about 3 years before this story reaches its turning point. 2 bedrooms, nice area, reasonable rent for the city. She'd looked at several places, she was methodical about everything, always had been, and Gerald's building had checked enough boxes. Good location, acceptable price, seemed well maintained on the surface. Seemed. The first month was fine. The second month, she started noticing things. The hot water heater was temperamental. Some mornings you got hot water, some mornings you got a lukewarm trickle, and on the worst mornings you got cold water and a noise from the utility room that sounded like an argument. She reported it in writing. She always communicated in writing, by habit, and Gerald acknowledged it warmly. Said he'd get someone out. No one came. Then she noticed the bathroom. There is a particular shade of black that appears on grout lines when the problem behind the wall has been going on for a long time. It's not the gray of ordinary bathroom mildew. It's darker, more diffuse, spreading outward from the corners in a pattern that has a kind of horrible patience to it. She recognized it immediately because she worked at a tenant rights firm and she had seen photographs of it in 100 case files. Black mold. She reported it in writing, formal this time, specific. She cited the location, described the visible spread, and referenced the applicable section of the state housing code. Gerald replied, still warmly, still friendly, and said he'd have someone take a look. No one came. The smoke detectors were next. She tested them the way she tested everything in a new apartment, systematically in the first week. 2 of them clicked and beeped weakly and then went silent. She replaced the batteries. Same result. The detectors themselves were dead. She reported them. Gerald said he'd handle it. He did not handle it. Now, here is where the story could have gone differently. A different tenant at this point would have done one of several things. They might have kept complaining and got nowhere. They might have fixed some of it themselves and quietly absorbed the cost. They might have grown frustrated, stopped paying rent, gotten evicted, and moved on with the permanent disadvantage of an eviction on their record. This is what Gerald counted on. He had seen it play out dozens of times. Tenants complain, tenants give up, tenants disappear. The building keeps generating rent. Life continues. But she was not a different tenant. She was a paralegal with 10 years of experience in tenant law, and she had been watching the clock. Her state, like most states, has statutes that require landlords to address habitability issues within what the law calls a reasonable timeframe. For serious issues, mold, heat, functional fire safety equipment, that timeframe is typically 14 days. Gerald was now 4 months past that deadline on the mold issue alone. He was in violation of state housing law. He had been in violation for over 100 days. She didn't confront him yet. She wasn't ready. First, She spent $350 of her own money to hire a certified mold inspector. The inspector arrived, spent 2 hours in the apartment, and produced a written report that was, in the inspector's own professional language, quite serious. The mold growth was not superficial. It had been developing behind the tiles for what the inspector estimated was at least 2 years. It was the kind of finding that, in a properly functioning system, would trigger immediate remediation. She uploaded the report to her cloud storage along with everything else she'd documented, every maintenance request, every non-response, every date, every photograph. Then she wrote Gerald a formal notice. Certified mail. Return receipt requested. She cited the relevant statute by number. She stated clearly and in plain language that she was invoking her right under state rent escrow law to withhold rent until the habitability violations were remediated. This was legal, completely, unambiguously legal. Gerald received the letter on a Thursday. By Sunday, he had decided she needed to go. Part 3, the escalation. When Gerald put that sticky note on her door, he thought he was making a simple business decision. The note said, "You have 30 days to vacate. New lease terms not being offered. Management." Handwritten, taped to the door. No signature. No legal citation. No formal notice of any kind. Just a piece of paper and an assumption, the assumption that had served Gerald well for 15 years, that the person on the other side of the door would read it, feel afraid, and comply. She photographed it the moment she saw it. Then she called her boss. Her boss had been practicing tenant law for 28 years. She had seen landlords do extraordinary things. She had seen things that, if you read them in a news article, you would assume were exaggerated for effect. She was not easily surprised. She laughed for 20 seconds when she heard about the sticky note. "That's not how any of this works," she said, still catching her breath. "Not a single word of that is legally valid. He can't terminate a lease with a post-it note. He can't even terminate it with a proper notice without grounds. You're in a rent escrow situation. He can't retaliate against you for that. This is textbook retaliation, and it's illegal." She paused. "Document everything," she said. "I'll be here if it escalates." It escalated. Gerald, in the weeks that followed, seemed to operate under the impression that he could simply make her life unpleasant enough that she would leave. This was a man who had never met a tenant who knew what he was doing. Every previous tenant had absorbed his behavior, or complained without legal language, or eventually folded. He genuinely did not know how to deal with someone who understood the rules of the game. So he kept playing the only way he knew how, which was aggressively, carelessly, and without any awareness of the evidence trail he was creating. The car was first. She came out one morning to find her space empty. Her car was gone. She called the towing company listed on the lot signage. They confirmed that the landlord had called it in. She paid the towing fee, $240, got her car back, kept the receipt, and added it to the file. Then the entries. She had installed a small, unobtrusive camera in her living room in the first month, a habit, she would later say, born from years of hearing clients describe landlord entries they couldn't prove. The camera ran continuously. It had a motion sensor and uploaded clips to the cloud automatically. Over the following 6 weeks, it captured Gerald, or someone acting on his behalf, entering her apartment 4 times without notice. She watched the footage each time with the detached professionalism of someone reviewing evidence rather than the visceral horror of watching a stranger walk through your private space. She saved every clip. She tagged them with dates and times. 4 illegal entries, all on camera. Heat was next. On a Thursday in February, when the outdoor temperature was 12 degrees Fahrenheit, Her radiators went cold. She called Gerald. He told her there was boiler maintenance happening. No advance notice had been given, which her state requires for non-emergency maintenance. She spent 3 days in her coat, sleeping under 2 blankets, taking her temperature readings every few hours with a digital thermometer and photographing the readout next to a clock showing the date and time. Temperatures in her apartment during those 3 days: 51 degrees, 48 degrees, 44 degrees. She added those photographs to the file. The rat appeared on a Wednesday, just sitting there on her welcome mat when she came home. She photographed it from multiple angles, noted the date and time, placed it in a sealed bag, and kept it in her freezer. She would later hand it to an investigator with the explanation, "I preserved it in case biological analysis is relevant." The investigator reportedly looked at her for a long moment before speaking. And then came the text. Gerald sent her a text message from his personal cell phone, which meant it was already logged, informing her that she owed $800 in administrative processing fees that had accumulated and were now overdue. She checked her lease thoroughly. There were no administrative processing fees anywhere in the document, not mentioned once, not in the main body, not in the addendums, not in the fine print. She replied to the text with a single sentence, "Please cite the lease provision that establishes this fee." Gerald did not reply. She saved the thread. Part 4, the night of the broken frame. And so we return to the hallway, to the fluorescent light, to the pile of her possessions, to the shattered frame and her grandmother's face behind broken glass. She had done everything correctly. She had been methodical. She had documented, reported, waited, and responded with the patience of someone who understood that in legal matters, impulsiveness is your enemy. She had done everything right. And Gerald had still done this. She stood in that hallway for a long moment, holding her grandmother's photo. She thought about the woman in it, the woman who had taught her that dignity was not something other people could take from you, only something you could give away. She set the photo down carefully, in a way that felt like a promise. She called the police. The responding officer arrived within 20 minutes. He was not unkind, but he was also not particularly informed. He told her, with the weary confidence of someone who has delivered this line before, that this appeared to be a civil matter, and that she should consider reaching out to her landlord to resolve it. She did not argue with him. She simply told him politely, respectfully, with the calm of someone who has researched this exact interaction, that he might be mistaken. She told him that under the state penal code, specifically the section covering unlawful ouster of tenants, what had occurred here constituted a criminal act. She told him the statute number. She asked him to look it up. He pulled out his phone. He searched. He read. He was quiet for a moment. Then he agreed to write the report. She thanked him. She had the report number before he left. Then she called Gerald. He answered. She had not expected him to, but he did, perhaps feeling the confidence of a man who had just, in his mind, solved a problem. She did not scream at him. She did not cry. She did not threaten him. She asked him in a level voice to explain what had happened. Gerald said, "You can sue me if you want. I got lawyers, you got nothing." She said, "Okay, thank you." And she ended the call. Her state permits single-party call recording. She had been recording from the moment he picked up. She sent herself the audio file. She uploaded it to the cloud. She labeled it with the date, time, and a description of its contents. Landlord verbal statement Ray, eviction, recorded with single-party consent. Then she drove to her friend's apartment, sat on the couch, and did not sleep for most of the night, not out of distress, though there was distress, but out of purpose. She opened her laptop. She organized every piece of evidence she had collected over the past several months into a single master file. She wrote a 12-page chronological summary of events with dates, evidence references, and applicable legal statutes. She built a timeline. She created an index. She was building a case file. It was, by the time she finished, the most thorough tenant complaint document her attorney boss had ever seen. And her boss had been doing this for 28 years. Part 5. The investigation begins. She filed the Housing Authority complaint the next morning. Housing authorities in most American cities are chronically underfunded and overwhelmed. They receive far more complaints than they can properly investigate. Inspectors are stretched thin, timelines stretch out, and the system, if you enter it as a generic complainant with a vague grievance, can feel like shouting into a bureaucratic void. She did not enter it as a generic complainant with a vague grievance. Her complaint was organized, specific, and documented to a degree that made it functionally impossible to deprioritize. It named the violations by code number. It attached the mold inspector's professional report. It referenced dates of non-response. It included photographs. And it listed the names and contact information of 14 other tenants who had indicated willingness to make statements. The Housing Authority investigator called her within 2 days. "We don't usually receive complaints like this," he said. She later described his tone as somewhere between impressed and slightly unsettled, which she took as a good sign. But the Housing Authority complaint, comprehensive as it was just the opening move. The real work had already begun somewhere else, in a Facebook group, of all places. 2 days after the illegal lockout, she posted in a local neighborhood group. She kept it simple. She mentioned she'd had a bad experience with a landlord who owned several buildings in the area, named the streets, and asked whether anyone had had similar experiences. The response was not what she expected. Within 48 hours, she had 23 replies. Not all of them were detailed. Some were just a yes, same building, same landlord nightmare. But enough were substantive to be worth following up. She sent personal messages. She made phone calls. She had coffee with several people. Over 2 weeks, she assembled a picture of Gerald's operations that was comprehensive, damning, and deeply consistent across 31 individual accounts. The stories overlapped in ways that could not be coincidence. Maintenance requests ignored for 6 months, a year longer. Landlord entering apartments unannounced. Fees appearing on rent statements that had no basis in the lease agreement. Deposits withheld entirely at move-out, with no itemization, no explanation, no recourse offered. Heat problems, mold problems, rodent problems. And in at least 2 other buildings, the same pattern she had experienced. A tenant who pushed back, who asserted their legal rights, who was subsequently harassed and pressured and eventually displaced. She documented all 31 accounts. She created individual files for each tenant with dates, amounts, and the specific violations implicated. She cross-referenced them. She built, essentially, a dossier. And then she found Marcus. Marcus had been Gerald's tenant 6 years ago. A quiet man, she described him later, the kind of person who tries to resolve things through conversation before anything else. He'd had a water damage problem in his unit that Gerald had refused to address. When the ceiling eventually actually collapsed, a section of drywall and plaster into his living room, Gerald had refused to pay for the damage to his belongings and had instead served him with a notice of lease violation for allegedly causing the damage himself. Marcus had fought back. He'd gone to small claims court without a lawyer, presented his evidence, and won a judgment of $3,500. Gerald had looked at the judgment, calculated that Marcus probably couldn't afford to hire an attorney to enforce it, and simply not paid. He'd continued operating his properties, collecting rent, giving handshakes at move-ins, telling new tenants his door was always open. The judgment had sat, unpaid, for 6 years. She made a note. She wasn't sure yet exactly what she would do with Marcus's situation, but she knew that an unpaid court judgment was a tool, and she was collecting tools. Then she went deeper. She spent a weekend in the public records system. Everything she needed was, technically, publicly available. Property records showing what Gerald owned and what was mortgaged against it. Court filings showing every case he'd been involved in. Business registrations for his property management operation. And crucially, licensing records for rental property operators. In her city, landlords who rent out more than a certain number of units are required to hold a valid rental business license. The license requires an application, an inspection, and annual renewal. It is not a difficult process. Most legitimate landlords do it automatically. Gerald had let his licenses lapse. Not for all 4 buildings, for 2 of them. But those 2 buildings contained approximately 28 units, and the lapse wasn't recent. One license had been expired for 19 months, the other for 26 months. She read the city ordinance 3 times to make sure she was reading it correctly. Operating rental properties without a valid license in her city does not merely result in a fine. It constitutes a violation that, under the specific language of the code, renders the lease agreements in those buildings legally void, and entitles each tenant to recover all rent paid during the unlicensed period as damages. All of it. 28 units, 19 to 26 months of rent, averaging $1,100 a month. She sat back from her laptop. She did the math twice. She was looking at, conservatively, $678,000 in tenant rent claims alone, before any fines, before any damages, before any penalties under the consumer protection statutes that also applied to operating without a license. Gerald had 4 properties. He thought he was a real estate success story. He had been building a liability. Part 6. The machinery of justice. People have a complicated relationship with bureaucracy. Most of the time, bureaucracy is an obstacle, slow, indifferent, grinding. It processes you. It loses your paperwork. It tells you to call a different number, fill out a different form, come back on a different day. If you enter bureaucracy as an ordinary person with an ordinary complaint, it can feel like throwing paper into a wind. But bureaucracy, when properly aimed, is also an extraordinary weapon. The key word is *aimed. She understood this in a way that most people don't, because she had spent 10 years watching attorneys aim it. She had done the research for those attorneys. She had prepared the filings. She had organized the evidence. She knew which agencies had jurisdiction over which violations. She knew which findings triggered which consequences. She knew how the gears of the system fit together. And now, for the first time, she was pulling the levers herself. The housing authority inspectors arrived at Gerald's 4 buildings within 3 weeks of her complaint. Gerald presumably knew they were coming. He would have received official notice of the inspection. He presumably tried to prepare. He presumably believed that whatever they found could be managed. He was wrong. The inspection team documented 47 code violations across the 4 properties. 47. Multiple units in every building had issues. The mold in her own apartment, the mold that Gerald had known about for 4 months and ignored, was cited, photographed, and formally classified as a Class A habitability violation. Non-functional smoke detectors in multiple units. Heating system deficiencies. Inadequate ventilation. Pest evidence in common areas. The list went on for pages. And then the licensing findings. 2 buildings, operating without valid rental licenses for 19 and 26 months respectively. The housing authority's enforcement action was immediate and automatic. There was no discretion involved, no negotiation. The fines were fixed by ordinance. $1,200 per day, per unlicensed property, retroactive to the date each license had lapsed. Gerald received an enforcement notice that, when she later saw a copy of it, made her close her eyes for a moment just to process the numbers. For one building, 19 months of unlicensed operation, 570 days, at $1,200 per day, per property. For the other, 26 months, 780 days. The fines, just from the licensing violations, had already accumulated to over $1 million on paper, with Gerald owing escalating daily penalties until he brought both properties into compliance. He scrambled, he hired an expeditor, he got his licenses reinstated, but the retroactive fines were fixed, they did not go away. Gerald, for the first time in 15 years of landlording, was genuinely frightened. He didn't know that this was still just the beginning. Part 7, the lawsuit. Her boss had been waiting for a case like this. Not waiting in a passive sense, she was a busy attorney with a full practice. But when her paralegal walked into her office with a 12-page case summary and a 3-inch binder of evidence, she recognized what she was looking at. She recognized it the way a craftsperson recognizes exceptional raw material. She took the case on contingency. That means she would take no upfront fee, she would collect only if they won. Taking a percentage of the recovery. It's an arrangement that attorneys make when they believe in a case strongly enough to bet their own time and resources on it. She said the evidence was, and this is a direct quote, asterisk, embarrassingly airtight. They filed the civil lawsuit in state court. The complaint was detailed, specific, and supported at every point by documentary evidence. It alleged 6 causes of action. First, illegal lockout, also called self-help eviction. Gerald had physically removed her from her unit without a court order. This is prohibited everywhere in the United States. Under her state's tenant protection statutes, the minimum statutory penalty for illegal lockout is 3 months of the tenant's rent, regardless of other damages. Her rent had been $1,450 a month. 3 months was $4,350, minimum, for this single act alone. Second, illegal entry. 4 documented instances, on camera, of Gerald or his agent entering her apartment without notice and without consent, also prohibited by statute. Third, breach of warranty of habitability. The mold, the heat shutoff, the non-functional smoke detectors, all documented, all reported, all ignored for months in violation of the state housing code. Fourth, retaliation. Gerald's actions, the sticky note, the towing, the entries, the heat, the rat, had all occurred after she exercised her legal right to withhold rent for habitability violations. Retaliating against a tenant for asserting legal rights is independently actionable. Fifth, intentional infliction of emotional distress. The campaign of harassment, taken together, met the legal standard for this claim. Sixth, conversion, a legal term for the wrongful destruction or deprivation of someone's property. The broken grandmother's photo. The other items damaged when her belongings were dumped in the hallway. All documented, all photographed. Gerald's attorney filed a motion to dismiss. It was denied. Gerald's attorney filed a counter-suit, alleging that she had damaged the apartment. He provided no evidence, and that she owed unpaid fees not established in the lease. He provided no lease language. At a pretrial hearing, the judge looked at the countersuit and then looked at Gerald's attorney for a long moment. She said, on the record, meaning it was transcribed and preserved in the court file, that the counterclaims were asterisk, not grounded in law or fact. She dismissed them with prejudice, meaning they could not be refiled. The trial was scheduled. Settlement discussions began. Part 8, the Army. She had spent 2 weeks talking to 31 tenants. She had collected their stories, their documents, their photographs, their grievances accumulated over years of dealing with Gerald's buildings. She had created files for all of them. But she was one person. She could pursue her own case. She could not simultaneously pursue 30 other cases for 30 other people who had neither the resources nor the legal expertise to fight on their own. So she made a phone call. There is, in most mid-sized American cities, an organization that does the work nobody else does, nobody glamorous anyway. Tenant advocacy nonprofits. They're understaffed, underfunded, and largely invisible until the moment someone needs them. They fight for renters who can't fight for themselves. They know the law. They know the landlords. They know the system. She had worked alongside similar organizations throughout her career. She knew exactly who to call. The nonprofit's legal director picked up. She described what she had: the 31 tenants, the licensing violations, the documented pattern across 4 properties, the class action potential. The legal director was quiet for a moment. "How organized is your documentation?" he asked. "Very," she said. "Can you send me the files?" "I'll send you the index first," she said, "so you know what you're looking at before you open everything." He later told a colleague that the index alone was more thorough than most of the complaints his office received in total. The class action was filed on behalf of 28 tenants, those in the 2 unlicensed buildings. The core claim was simple. These tenants had paid rent to an unlicensed operator in violation of city code and were entitled to recover every dollar of rent paid during the unlicensed period. 28 units, averaging $1,100 a month, an average of 22 months of the unlicensed period applicable to each unit. $678,000 in base rent claims, plus damages under the state's consumer protection statute, because operating a rental business without a license constitutes a deceptive trade practice. Consumer protection statutes in most states allow for multiplied damages, meaning the court can award 2 or 3 times the actual harm as a penalty for deceptive conduct. Plus attorney fees, which in consumer protection cases are often awarded to the prevailing plaintiff. Plus the class action's own attorney fees, separate from the individual damage claims. The total potential exposure, once the nonprofit's legal team ran the numbers, was somewhere between $1.5 and $2 million for the class action alone. Gerald's real estate attorney described the filing to another attorney as asterisk, an existential threat to Mr. Gerald's business. That description was accurate. Part 9, the criminal reckoning. She had a police report. She had a recording. She had photographs and witness statements. She had everything. What she did not yet have was a criminal charge. Self-help eviction is a crime. In her state, it is classified as unlawful ouster, a misdemeanor, but a criminal charge nonetheless. The police officer who had responded that night had written the report, but no one had yet taken the step of bringing it to a prosecutor. She made an appointment with the city prosecutor's office. She arrived with her binder. She presented her evidence, the photographs of her belongings in the hallway, time-stamped, the police report, the recording of Gerald's phone call, asterisk, "I got lawyers, you got nothing." 2 written statements from neighbors who had witnessed the lockout, the documentation of the 4 illegal entries captured on camera. The prosecutor's intake coordinator, who had presumably seen thousands of tenant complaints, looked at the materials for a while without speaking. "This is very organized," she said finally. "Yes," she said. "It took 4 months. These things always take longer than they should." But the criminal complaint moved forward. Gerald was charged with unlawful ouster, criminal self-help eviction, and criminal trespass, the latter stemming from the documented illegal entries. Gerald's attorneys worked to minimize the criminal exposure. They were partially successful. The criminal trespass charges were reduced to civil infractions, which removed the criminal component. But the unlawful ouster charge was not reducible. The evidence was too clear, the statute too specific, the recording too damning. Gerald took a plea deal. No prison time. He was 61 years old with no prior record, and the prosecutors were not seeking incarceration. But the plea came with conditions that Gerald found, by all accounts, deeply humiliating. A criminal record. 18 months of probation. Mandatory enrollment in a landlord compliance and tenant rights training program. The man who had told her she had nothing was now on probation. He had a criminal record that would appear in any background check. He was required by court order to attend a class, to sit in a room and be told, by instructors, what his legal obligations to tenants were. She heard about the plea deal from her attorney, who called her at the end of a workday. "He pled," her attorney said. "Good," she said. There was a pause. "How are you feeling?" her attorney asked. She thought about it. "Like there's one more thing to do," she said. Part 10, the bank letter. This is the part of the story that people find most surprising. Not the housing authority fines, not the lawsuit, not even the criminal charge. Those are all part of a recognizable, if rarely executed, playbook for fighting a bad landlord. The bank letter was something else. She had been thinking about it since the weekend she spent pulling public records. Gerald's 4 properties were mortgaged. She had found his lenders through the property records, and she knew something about commercial real estate loans because she was a paralegal who worked around legal documents every day, and commercial loan documents were not unfamiliar to her. Most commercial real estate loans contain what are called loan covenant clauses. These are requirements the borrower must maintain throughout the life of the loan. They typically include things like maintaining adequate insurance, keeping the property in good repair, and this is the relevant part, operating the property in compliance with all applicable laws and regulations. Violation of a loan covenant is typically classified as a technical default event. That means the lender has the right, not the obligation, but the right to demand immediate repayment of the full outstanding loan balance. Gerald had roughly $3.2 million in outstanding mortgage debt across his 4 properties. She composed a letter to each of his lenders. It was factual, measured, and meticulously documented. It stated that 2 of the mortgaged properties had been operating without valid rental business licenses for 19 and 26 months respectively, and attached the housing authority's enforcement documentation confirming this. It stated that those same properties were subject to a class action lawsuit with potential damages estimated at $1.5 to $2 million, and attached the filed complaint. It stated that those properties were under active housing authority enforcement with accruing daily fines, and attached the fine notices. It stated that a criminal matter was pending against the property owner, and attached the charge information. It then noted, carefully and without drawing a legal conclusion, that commercial real estate loan agreements typically include covenants requiring legal compliance with applicable regulations, and that the lender might wish to review the relevant loan documentation in light of the documented circumstances. She sent the letters by certified mail, return receipt requested, the same way she had sent Gerald his habitability notice 9 months before. 2 weeks later, Gerald's attorney called her attorney. He was not calm. He accused her of tortious interference with Gerald's business relationships, a legal claim that, in plain language, means wrongfully disrupting someone's business dealings. He demanded that she retract the letters. Her attorney asked him, very calmly, to identify a single factual inaccuracy in the letters. He could not. Every statement in the letters was documented. Every claim was supported by official records. She had not expressed opinions. She had not made predictions. She had communicated documented facts to parties with a legitimate financial interest in those facts. Her attorney told him to have a nice day. She hung up. Gerald's bank sent him a notice of technical default. He had 30 days to submit a remediation plan, a detailed explanation of how he intended to resolve the outstanding violations, the pending litigation, and the criminal matter. If he could not demonstrate a credible path to resolution, the bank had the right to accelerate his loans. Accelerate means call due immediately, all $3.2 million. Gerald spent those 30 days in a state of crisis that, by multiple accounts, he had never experienced in 15 years of operating his properties. He hired additional counsel. He paid expeditors to resolve the licensing violations at maximum speed. He engaged with the housing authority's remediation process. He had conversations with his lenders that, from all appearances, were very unpleasant. He resolved the technical default. The bank did not accelerate his loans. But the experience had cost him, in legal fees, in expedited remediation costs, in the sheer time and energy of crisis management, a very large amount of money. And the class action was still pending. The housing authority fines were still accruing. His criminal plea was already entered. Gerald began the process of selling 2 of his 4 buildings. Part 11, THE settlement. 14 months. 14 months from the night she stood in that hallway holding her grandmother's broken photo. 14 months of documenting, filing, coordinating, testifying, organizing. 14 months of treating her own situation with the same methodical professionalism she brought to every client case she had ever worked. Gerald's attorneys reached out to her attorneys with settlement discussions. She had always expected this. Cases like hers, with evidence this strong, rarely go to trial. They settle because the defendant's attorneys eventually do the math and recognize that the cost of a trial loss exceeds the cost of a settlement offer. The calculation is cold and purely financial. It has nothing to do with justice, technically speaking, but the financial pressure that produces it is something she had helped build deliberately over 14 months. She had made Gerald's position untenable. The settlement was the inevitable result. The details of settlement agreements are typically confidential, and she has honored that in what she has shared publicly, but the broad strokes are known. The settlement covered the statutory lockout damages calculated at 3 months of her rent, her full security deposit, which Gerald had been holding, the $350 mold inspection she had paid out of pocket, the towing fees, the documented property damages from the illegal lockout, and a substantial additional payment, a number she has not disclosed specifically, that reflected Gerald's interest in resolving a case that, without settlement, would have gone to trial with video evidence, a call recording, and a judge who had already dismissed his counterclaims as legally frivolous. The total received $187,000. Class actions settled separately through the nonprofit's legal team. She was not a party to that settlement and was not privy to its specific terms. The nonprofit's newsletter described the outcome as asterisk, significant and equitable to the class members. Based on what she knew about the exposure and the typical dynamics of these settlements, she estimated the figure was somewhere between $700,000 and $900,000, distributed among the 28 class members. The Housing Authority fines, by the time Gerald brought his properties into full compliance, totaled $287,000. Marcus, the man who had won his $3,500 judgment 6 years ago and then watched it sit unpaid while Gerald simply waited him out, received, with the help of her attorney, a renewed enforcement action. Gerald paid the judgment in full, plus 6 years of statutory interest, which had compounded to an additional $840. Marcus used the money toward a 2023 Honda Accord. He found her post online after she wrote about the case publicly, and he identified himself in the comments. He said he had been crying for about 20 minutes. She replied that she was glad he found her. She congratulated him on the car. The internet, in a display of collective sentiment unusual for the internet, agreed that Marcus deserved that car. Gerald sold 2 of his 4 buildings. His remaining properties are under mandatory quarterly inspections by the Housing Authority for the next 3 years. He has a criminal record. His state real estate license was suspended pending investigation by the licensing board, a proceeding that, as of the time this story was written, had not yet concluded. He completed his mandatory landlord compliance training. He also, presumably, lives with the knowledge of what happened and why. The total financial and legal exposure she triggered against him, the Housing Authority fines, the civil settlement, the class action settlement, the costs of the technical default crisis, the legal fees, adds up conservatively to somewhere north of $2.3 million. He told her she had nothing. She had a mold inspector's report, a camera, a phone set to record, 10 years of paralegal experience, a Facebook group, 31 tenant testimonies, a public records database, a knowledge of loan covenant clauses, and 14 months. That, as it turned out, was quite a lot. Epilogue, Lisbon. She wrote about what happened in an online forum for people who have fought back against those who wronged them. She wrote it plainly, in the same methodical way she does everything. She organized it in phases. She included the relevant numbers. She ended it with the image she most wanted people to carry away from the story, not the fines, not the settlement, not the criminal record, but a photograph. Her grandmother's photograph. The original negative had been in a box at her parents' house. She found it during a visit, held the small strip of film up to the light, and saw the image there, her grandmother's face, the woman whose eyes she had inherited, captured by some anonymous photographer on some ordinary day decades ago, somehow surviving in a cardboard box while the world changed around it. She had it reprinted, properly on good paper, in a frame she chose carefully. It hangs now on the wall of her apartment in Lisbon, Portugal, the city where she had taken a sabbatical with some of her settlement money, the city where she was sitting when she wrote her account and posted it online, where 47,000 people upvoted it and thousands more wrote in the comments that they had saved it, shared it, printed it, that it had given them courage to fight their own battles. She ended her account with something simple. She said that the photo of her grandmother was beautiful, that Lisbon was beautiful, that those 2 things together were enough. I've thought about that ending a lot, because I think she is being honest when she says it's enough. I don't think it's a performance of graciousness or a tidy bow on a revenge story. I think she genuinely means it. I think that for a person who spent 14 months doing the hardest, most precise, most disciplined work of her life, not the work of anger, but the work of truth, of documentation, of patient and methodical insistence that what was wrong should be made right. The outcome she cared most about was not the number on the settlement check. It was the photograph on the wall. The rest, the $2.3 million of exposure, the criminal record, the probation, the sold buildings, the quarterly inspections, the mandatory compliance training. That was just what happened when you picked a fight with the wrong person. Gerald wanted an empty apartment. He got all of that instead. And if you're watching this because you're dealing with something similar, a landlord who ignores you, intimidates you, takes your money and gives you nothing in return, then let me leave you with the practical lessons buried in this story. Document everything, every maintenance request in writing, every response or non-response, every date, photograph everything. Learn your state's habitability laws. Most states have 14 to 30-day requirements for serious repairs. Most states have rent withholding or rent escrow provisions. Most states have anti-retaliation protections. Know your local housing authority. It is free to file a complaint. It may be the most powerful thing you do. Look up your landlord's licensing status. In many cities, it's public information. In many cities, unlicensed operators face serious consequences. If your landlord has mortgaged properties, which most do, understand that lenders care very much about legal compliance. They care about it in writing, in the loan documents, in the covenant clauses. That is not a secret. It is just information that most tenants don't know to look for. And find your local tenant advocacy nonprofit. They exist in most cities. They are free to contact. They are often waiting for someone to bring them a case they can actually use. You may not have 10 years of paralegal experience, but you have a phone with a camera. You have email. You have public records. You have the same laws she used because they're your laws too. Gerald was right about one thing. She could sue him. He was wrong about everything else.